Today's webinar is entitled Demystifying the Estate Planning Process. Our presenter is Robert Constantine, Director of Planned Giving at Rochester Institute of Technology, a role he has held since 2011. Prior to joining RIT, Robert practiced law for more than 25 years in Buffalo as a partner with Damon & Mori, LLP, now Barclay & Damon, limiting his practice to trust and estate and charitable gift planning, focusing on families, business executives, and medical and other professionals. Robert is an elected fellow of the American College of Trust and Estate Counsel, and he practiced in both New York State and Florida during his law career. Robert moved to the financial services field, where he was a first vice president with HSBC Private Bank and served as regional head of the personal trust business in upstate New York from 2003 to 2010. Robert is a graduate of the University of Pennsylvania and received his JD and an MBA degrees from the State University of New York at Buffalo. Robert, take it away.
Thank you, Lydia. Good afternoon, everybody. Glad you could join us today. This is intended to be basically an introductory seminar that allows you to get a feeling for the estate planning process, what your role is going to be, understanding some of the terminology that you're going to come across, working with professionals. All of this will help keep some of the expense down in getting a customized estate plan in place for you. So this is basically what we're learning, what I want you to hear today, but also, see if I can move it forward. The next screen isn't happening. Okay, let's get into what is this, and you're also going to hear about what is estate planning, what you're going to need to do to get it, and how you're going to get it started. The importance of how titling your assets is. In other words, are they in your name? Are they in joint name? Are they going to be in the name of a trust? If they're in, if you have assets that are governed by beneficiary designations, the importance of having current and updated beneficiary designations for things like life insurance and retirement plans. As I said, we're also going to talk a little bit about the process of working with attorneys, financial planners. This is your team that is going to assure that your estate plan is customized and most appropriate for you. Not surprisingly, there's no such thing as a cookie cutter, that thing that fits, everything fits for everybody. Understand that you are a unique individual with unique family and asset and life experiences and values, and your estate plan should reflect who you are and what your intentions are for your heirs. So we got to get organized in order to have an estate plan in place. Estate plans are going to be different for you based on your life stages. So there are a number of different factors that are going to impact the importance of the estate plan that you have for yourself, and these vary from time to time during our life stages. For example, a young couple recently married or just had children. Their focus at this point, perhaps they haven't had the opportunity to really accumulate significant assets, and yet their focus is going to be on making sure that there are guardians for their infant children. Guardians normally have to be appointed by the parents, and usually the place to do that is in a will document. So that is generally the most frequently used purpose for having an estate plan when people are younger. And I have to say that in practice, when I did a lot of wills for younger people, it also was the greatest area of indecision as to who should be the guardian for our minor children, or even for those who are adults, where you have a disabled child or heir that you want to make plans for. So in this early stages, you'll also be establishing trusts for minors, and the reasons for having trusts is because minors legally cannot own assets. If somebody is disabled, they may be unable to handle their own business affairs, and even if somebody is not disabled and not a minor, they may be inexperienced in the ways of the world, inexperienced in handling and managing assets, and it's sometimes the best plan is to delay the full enjoyment of those assets by keeping them in trust under the guidance of a valued trustee who can help educate that heir as well as manage the assets while that heir continues through the period of inexperience. So selecting who is going to be responsible as the executor, guardian, or trustee. We're going to learn a little about the term executor in different states. That's a term that's fairly common in states like New York. Many other states use the term personal representative as the person who assumes responsibility for handling the affairs of an estate. Where to get started? One of the handouts that you will be able to access once this webinar is online in about a week, I have 3 handouts that you'll have access to, one of which is an estate planning questionnaire. This is a form that will help you get organized. It prompts you for certain information. Many attorneys that you work with have their own format. I think you can start with the one I provided you, and then if the attorney has one that's substantially different, you can complete the questions that haven't been asked. The one I'm giving you is relatively generic and assumes that you're going to add information, not try to keep all the information on the little lines that I provided for you. So an estate planning questionnaire. This is just an organizational detail. You'll be answering questions such as your financial and personal information, who you are, who's your family, the usual kinds of things that you expect in an estate planning questionnaire, but other things that you might want to enter in here. This is information such as where's my deed and real estate title papers, where are they physically located? Are they in the safe deposit box? Where's the safe deposit box located? Where's the key located? Who has access to the safe deposit box in the event that I'm not able to get there myself? Life insurance information. Who's my insurance advisor? What policies do I have? Who owns the policies? Do I own them? Are they in a life insurance trust? Who are the beneficiaries? Who are the primary beneficiaries? Who's the remainder beneficiaries? To the extent that you have this information available, it's good to have things such as policy numbers, and even if there are loans taken against them, it's not as important the amount of the loan as much as the fact that there may be a loan outstanding against them. Where are the retirement accounts? Once again, who are my beneficiaries? Who are my primary beneficiaries? Who are my remainder beneficiaries? Bank and financial accounts, where are they located? How is the title held? Lenders. It's important that those who are asked to administer your estate after you're gone have full information about the obligations that the estate will have. This also is an important piece of information. If you have outstanding debts and other obligations, a financial planner will make sure that you have adequate liquidity and understand what the timing is going to be and the timing requirements might be in order to satisfy all those obligations. A mortgage, for example, is not ordinarily due and payable when somebody dies. So that you don't necessarily have to plan to have money immediately available to pay off a mortgage, and yet there are other kinds of loans that may be due on death. So this is information that's important to be collated in a single spot so that you and your advisors can give you the best advice and anticipate these issues as they come up. Also, it's important to have memorialize the online account information. The world of social networking, there have been articles in various publications about things like trying to shut down your Facebook account, but nobody has the password, and Facebook won't give access to anybody with those, and that can cause problems when you, frankly, would like to cease having a life on the Internet after your life on the Earth is gone. So list those accounts, list the log-on information, passwords. I realize there's a security issue, but I think if you keep it in writing and keep it someplace that it's accessible to those who need to know, it's a good thing to have in place. I mentioned earlier a little bit about how important it is to understand how all of your assets are titled. For example, many of those who are married will have homes or their primary accounts, checking accounts, bank accounts, and even investment accounts in what's known as joint tenancy. Joint tenancy is a form of ownership in which two or more people have an equal common interest in the asset. And state law will generally control what happens when one of those joint tenants dies. Frequently, it just means that by operation of law, the survivor is the owner of the asset. For example, husband and wife own a piece of real estate, their primary residence, wife dies, title is now in the name solely of the husband. Yes, it may make sense to notify the the local town or municipality that sends out the tax bills just to change the name of how the tax bills will be issued, but that does not impact the fact that by law, the only person at that point who owns the property is the surviving joint tenant. So when it comes time to sell the property, the only item you're going to have to show is a death certificate indicating that one of the joint tenants has died. That permits the survivor then to transfer full title. Another type of ownership is to have an account titled in such a way that on the death of one, the title will pass, or the assets will pass to named survivors or named beneficiaries. This is a transfer on death account. Started in the banking industry many years ago. It was John Smith, and then pay on death to Jane Smith, or to Joe and Jill and Jennifer Smith. The three beneficiaries there have no interest currently in the account. Their interest only accelerates upon the death of the account owner. But what happens is there's an immediate and very efficient way of transferring assets on death without further court administration or any other legal administrative requirements. Once again, just a death certificate is usually all that's required in order to get those accounts transferred to the named beneficiaries. Beneficiary designation, we already talked a little bit about this. Life insurance and a IRA and other retirement accounts are merely contracts. So you contract with Prudential that you agree to pay the premiums annually, and they agree to pay the death benefits to whomever you designate as the beneficiaries. So the beneficiary designation is an extremely important piece of that contract, not only for the primary beneficiary, but also what happens if the primary is deceased or disclaims the right to receive the assets. You should have secondary beneficiaries, and that should be part of the consideration and part of your estate planning. Same with an IRA or other retirement account. Those are essentially contracts between you as an employer, contract between you and your employer, you as an employee, and then the employer and the administrator of the retirement account. Or if you have an IRA or 401k, that you have the same, you in fact are the one who has the contractual relationship with the administrator of your IRA. So in those cases, once again, the beneficiary designation is extremely important and needs to be part of the whole estate planning process. All of these things that we talk about here that you see, as you can see, you can designate who is going to get the property after the death of the first owner. You haven't heard anything about it passing through a will or going through probate. These are effectively methods of passing assets along without having to go through the court system, without having to go through the probate system. It's one of the reasons there was public sentiment in getting these types of ownership arrangements put into the statutory scheme in many states, and it's becoming much, much more popular these days. A trust is nothing really other than a contract between the person who sets up the trust and the person named as a trustee. And in many cases, if this is set up during lifetime, those can be the same people. And any assets that are retitled, any assets that are put into the name of the trust, will pass according to the terms of the trust. So once again, there's its way of having assets held by an entity, and that entity, upon death of the trustee, death of the person who sets up the trust, the terms of the trust will continue and will describe what happens with those assets and how long they're going to continue to stay in trust. Will they stay in trust for a term of years? Will they stay in trust until somebody reaches the age of 25, 30, 35? Whatever, they're extremely flexible, and they can be used as a powerful term.
Excuse me, Robert, we have one quick question here, and we wonder if you could give a brief explanation of what the probate process is after someone dies. So let's say I'm a spouse and my husband has died. What are the things that are going to happen in the first processes of distributing the assets and going through a probate?
Okay. While I answer this question, I'm going to do a little homework for you. Let's first just do a quick survey on the, I want to hear from the attendees, where are we in the life stages? So if you could, yeah, so we'll set that up in a minute here. But let me so while we're getting that set up, let me answer the question on probate. Probate comes from Latin. Anybody who had to go through that during elementary school or high school knows it comes from probare, to prove. So a will is a legal instrument that has no legal effect while you're alive. No legal effect while you're alive. The only way it's going to have legal effect is when that will is presented to a probate court, and the judge of that probate court is satisfied that, in fact, this is the last will and testament and meets all the qualifications as required by law. A number of witnesses that was signed by the testator, the person who signs the will, that it was signed, that he knew at the time that he was signing it, that it, in fact, was a will, all those kinds of things. Was not under duress and was not under any kind of undue influence, and also had a general but a very low standard of understanding as to what was going on. Capacity is a very important part of whether or not a will is going to be validated by the court. So once the court is satisfied that all of these things were done properly, the will was signed properly, then the court admits the will to probate, meaning that the will now will control any assets that were not passed, that did not pass by one of those other methods that are already up on the board there, the joint assets. Assets that don't pass outside of the will be now controlled by the executor, who is appointed by the court. So the will designates a person who acts as an executor or personal representative. When the court admits the will to probate, feels is satisfied that it was valid in all respects, Then the court gives full authority to the person named in the will to execute the terms of the will, and then whatever that says in there, the executor has the responsibility and has the ability to collect the assets, to negotiate with creditors, and then ultimately to file tax returns, pay taxes, and then ultimately to distribute in accordance with the terms of the will. How long does the probate process go? It all depends on the complexity of the assets. It depends on whether or not there's going to be any estate tax. Usually the delay in probate is a function of, and this assumes that there aren't any challenges to the will by an irate heir, but usually it can be done in as short as 6 to 9 months, and that is merely just a function as to how long it takes to work with the holders of the assets, the bank accounts, the investment accounts, other assets that are around there. Somebody has to file a final income tax return, presumably for the person who dies. That's usually the executor who does that. So there are some odds and ends that have to be done. Many of these things can be done and avoided by using a lifetime trust, which is up on the board there, the last item. So if all the assets are either among all the joint assets, or you've got transfer on death accounts, beneficiary designations, and a lifetime trust, then in most cases the necessity of probate is avoided. Nevertheless, everyone should have a will, regardless of how completely they have planned their estate. A will, as I always say, a will is the right instrument to have, so that when you have a heart attack holding that $60 million lottery winning ticket that you haven't had a chance to put into the trust yet, that's going to be controlled by your will. Okay, now so we have a little, our first of our quick questions. Tell us which age group you fit into. In other words, which life stages. Are you 20 to 40? So just check the one that applies there, and we'll give you about a minute to do that. That'll give me a little bit of a feel for who we have in the audience out here, and to a certain extent I'll tailor some of the discussion for some of those. While we're doing that, while we're doing that, let me go on to the next item. We think of estate planning as being just the act of passing assets along at the time of death, but the reality is a lot of the estate planning process also prepares us for what is going on during our lifetimes. The idea is that we should have in place the documents and the facilities that enable somebody to take over if we are unavailable or unable, if we're traveling and legal matters need to be taken care of during your absence. Who's going to handle those things? Well, there are a number of solutions to that. A fairly common one is using what's called a durable power of attorney. Each state authorizes an individual to designate another individual to act on his or her behalf. And that's called a power of attorney is the form, and we refer to it as durable because the power of attorney will stay in effect even if the person who signs it, the principal, becomes disabled, disabled as a result of illness. Obviously, on death, the power of attorney is no longer operative. It has no longer any legal effect on death. Do we have results on our survey? Do you want to share with us? Okay, so there are the results up for you to see. We have a few people who are thinking about the need for guardianship, and I'm glad you're with us today. Lots of you are in the 41 to 55, so your kids are at the point now where they're starting to get a feel for their abilities to handle certain things. You're probably getting up to the point where you're approaching or thinking about college. You're also believe it or not, in the asset accumulation phase. And you're hopefully working with financial planners and estate attorneys. Those of you 56 to 70, the second largest group on the phone today, are perhaps looking at retirement. Maybe most of those college expenses are behind you, still hopefully in the asset accumulation phase, in spite of what the stock market did last week and this week. But so this is also timely. And for those of us over 70, well, you're probably looking at this having done it before and looking to update your information, which raises the next question: how often should you be updating your estate plan? Well, certainly anytime there's a life event, a death, close relative, an inheritance. If you change physical location outside of one particular state to another, it's always best to have a local attorney in your new state review your documents to make sure they are fully operative and the best vehicles for that particular state. There are a number of states, most of the states in the U.S. have what's called community property laws, and the ownership of assets in a marital relationship. There is a commonality of ownership of assets that are acquired after the date of the marriage. And New York does not happen to be one of those. New York is one of the 19 states, I think there are 19 that are what are called common law states, where a spouse does not necessarily acquire ownership to assets just by virtue of the fact of that they were acquired after marriage. So it's important whenever you move out of state to get these updated. I would say any other life changes, so birth, marriage, they always say both biopsy. Anytime you get a bad biopsy result, it's probably a pretty good time to take a look at your planning. But at these various stages, the kids are up and off on their own. Not a bad idea to take a look at your things and see whether or not the planning that you put in place 15, 20 years ago is still the best plan for you. Do you have trusts sitting there that terminate when the children reach 21 and your youngest child is now 31? So I suggest that you keep a copy of your plan with your tax information, so that each year as you're putting together your information to do your income taxes for the next year, you're pulling out the plan and just taking a quick look at it. Have there been any changes that would suggest changes in the laws that suggest that you might want to have somebody review this with you? So let's step back for a minute again now to the solutions. We talked about a durable power of attorney. I happen to believe that a durable power of attorney should be a document that everybody has in place. You can have them set up so they're what's called springing powers of attorney. They don't come into play until you are disabled and your physician declares that you're disabled, in which case the agent that you've designated now has full authority to act. I never liked those when I was practicing law. I thought that they were administratively difficult to get. I found some physicians were unwilling to sign the paper that we needed in order to get this thing springing. My solution to this is to have a immediately effective, durable power of attorney. Give it to one and more persons, who you are confident will be honest and will be able to act on your behalf if you are not available or not able to do so yourself. One solution to the fact that sort of the trade-off between the springing power and the immediately effective durable power of attorney that I used to do once in a while, somebody would say, well, I'm willing to name my kids, but I frankly don't want them to have this immediately. But I do understand that you don't like the springing power of attorney. So I would recommend, why don't I hold on to all of the originals of the power of attorney, and then when somebody notifies me, and will notify the kids that I'm holding them all, and then when someone notifies me that there's a need, I will release the power of attorney. That's not the perfect solution, but it is a solution. So that's one possible solution to the issue. And then I also mentioned earlier living trust. Living trust will allow for somebody to manage your assets according to a schedule or according to a script. The terms of the trust will dictate how the assets are to be used while you're alive, and if you're not alive, then how they'll continue to be held for those who are near and dear to you. So a little more detail in there, but it doesn't, somebody who is a trustee of your living trust does not necessarily have the same power that somebody in a power of attorney does to perhaps communicate with the Internal Revenue Service, for example. End-of-life decisions. There's been enough play on this that you should all have in place healthcare documents, healthcare proxies. Every time you go to the doctor or go into the hospital, you know that they present them to you. It essentially is required under the federal privacy laws, the HIPAA laws, health information privacy laws, that basically say they cannot share information with anybody unless that person is authorized in writing to receive information. So I suggest always that you have in place a healthcare proxy. A healthcare proxy designates somebody to act on your behalf and to communicate with your healthcare providers and to make healthcare decisions for you if, now this is a difference between this and the durable power of attorney, this comes into play only if you're not able to make those decisions yourself or able to communicate those decisions yourself. Up above, I told you the power of attorney basically can be used for financial matters while you're alive, while you're healthy, but just perhaps unwilling or unable to do things for yourself, traveling out of the country. Healthcare proxy only kicks in when you're not able to communicate or make decisions for yourself, in which case the agent is directed to act on your behalf according to what your agent knows to be your wishes. So they're conveying your wishes, not necessarily their wishes, and those may, in fact, conflict with one another. You may have strong opinions as to maintaining life at all costs, and your agent has to know and understand that it is your wishes, not your agent's wishes, that are to be the controlling factor when acting under the proxy. So how are those wishes made known? Well, you can put them in the proxy themselves, but a lot of people use what's called a living will. Now, a living will, it's actually kind of a bad name. It's not really a will. All it really is a non-legal document that is an expression of what your wishes are and act as guidance to the person the agent holding your healthcare proxy. So healthcare proxy relates only to your healthcare decisions. Durable power of attorney will cover anything other than and expressly cannot cover healthcare. So those both need to be in place, and then the living will is an important document that gives guidance.
Robert, we have one question that's up, going back to the question of assets and assignability of them. Is it true or false that all assets in joint tenants are immediately available to the other person?
That is true. And joint tenancy law is established by each of the states, so check with your own state. There are a number of different accounts in which you can put somebody on as a matter of convenience, where they have like a power of attorney and can only act on your behalf. There are other accounts that are pay on death, where the person has no ownership interest during your lifetime. But if it's in joint name, either joint tenant has immediate access to some or all of the assets, yes. So that is correct. That is true. Now, this might give us an opportunity to ask one more question. No, you know what, let's go on to the next things here for a minute, and then we'll ask the question. So we talked a little bit about a will. So you now understand that a will is kind of a catch-all document. This is the basket that's going to catch anything that slipped off the table that wasn't controlled by some other method of ownership. It appoints an executor, someone who will execute the terms. It needs to be offered to the court, the probate court, to be admitted to probate before it is operational. You have to die before it becomes legally effective. It is frequently used to name guardians, and you can designate a guardian of the, this is something important I think for younger people who are struggling with, do I name my sister-in-law as the guardian or my brother as the guardian? My brother is great person. I love him to raise my child the way I think that we would raise him, and yet my sister-in-law has a great understanding and fiscally responsible, whereas my brother-in-law would unfortunately not have the same kind of control. Well, you can name both. You can name a guardian of the person who is going to have custody and raise the child according to the way you would like it raised. And you can name somebody else the guardian of the property who oversees the money. Or you name a person who is just the guardian, and you have the assets continue in a trust, and the trustee will oversee all the financial requirements and will pay money out to the guardian as the trustee, as you direct. And usually I've said very liberally, I mean, you really want money to be available to the best interests of the child. And that may mean if you've got 3 kids who are now suddenly moving into your sister-in-law's house, it's not inappropriate to expect a trustee to build another bedroom or 2 onto that house. That's an appropriate use of your estate assets. Those are the things that you might do when you have the 2nd and 3rd child, is go to a bigger house or add on to the house. So those are the kinds of things, the kinds of flexibility you can put into trusts. So a living trust is a way to hold assets during your lifetime. These are usually set up so they are revocable, meaning they can be changed or altered during lifetime. They're usually set up by an individual as his own trustee or her own trustee or co-trustees. You can designate others who will step in if you resign or become unable to manage your own financial affairs, and that person now moves from a successor trustee, becomes a successor trustee, and now will operate that trust on your behalf. The trust can continue after your death, as I mentioned before, and provide income to income beneficiaries, and then at whatever time you say the trust terminates, it will terminate, and then the assets, whatever's left, will be transferred to the remainder beneficiaries. Trust can be set up, as I said, during lifetime, called a living trust, or sometimes called an inter vivos trust. There's Latin. Important to know Latin, because if you go to cocktail parties, you have to know Latin. Inter vivos trust just means a trust set up between living persons. A testamentary trust is created actually in the will. So that's not in place until you die, until the will is submitted to probate, until the assets are ready for distribution, and then instead of being distributed outright to individuals, they're distributed to a trustee who's named in the will, might be the same person who's the executor, and now the testamentary trust begins to operate with the assets that have come through the will. Beneficiary designation forms, I talked about the importance of having both primary and secondary, and actually we jumped ahead earlier on that question, and so I hope I've answered that question as to what probate is. So we have a little opportunity here to ask a question, another question. Tell us which of these legal documents you actually have in place, and obviously you can Check all of the boxes if you want to do that, including, well, don't check them all because the last one is none of the above. That would be a little bit inconsistent. But let us know. I'm just curious as to what you've done, and maybe that's maybe you're not sure what you've done. But take a look at this, and if you have a will that has a testamentary trust in it, you would have both A and C as an example. Okay, well, we're tallying up that. You're going to be working with professionals. This is your team. You work with a financial planner, and a lot of them have credentials attached to them. I happen to believe in credentialing. It suggests to me that someone takes the extra steps of studying, taking additional courses, perhaps taking an exam that entitle them to use a series of credentials after their name. I have no opinion as to which are the strongest or the best, but clearly it's worth your taking the time to look into any credentials that your financial planners or estate planners have after their names. I think you'll see for yourself that some are a 20-hour correspondence course and others are 6 months long or a year long and require a series of testing and examination. So financial planners come from initially out of the, I'd say the insurance industry, life insurance, sales principally, and when the Glass-Steagall Act was eventually overturned and that permitted banks and others to get into investments, the whole titling of financial planner expanded rapidly. So you have financial planners who are in banking or may have come out of insurance, or may have come out of investment management. So they come from a variety of different backgrounds, and I think it's important for you to understand who it is that you're working with, how they get compensated. In other words, do they get paid by the assets that they administer, or do they get paid only if they sell you a product? And it's not to say that they won't give you good advice. It's just, I think, always important to know how they're getting paid. Okay, let's take a look at our results. So how have we done here? So about half of you have wills. 3 out of 38, in fact, have a living trust. Some, by the way, some states, you'll see a lot of people in Florida, predominant people down there have living trusts. California has a lot of living trusts. And that is a perception to a certain extent and a reflection of the complexity of the probate systems in those particular states. We're seeing more living trusts in New York as well. So we have one person who has a will with a testamentary trust in there. Glad to see that beneficiary designations are large. We need more powers of attorney. This is on your homework list. And healthcare proxies, I was hoping to see that being larger. Okay, so all of you, the none above, I'm delighted to have you on this call, and I hope this will provide you information and motivation to get some of these things in place for you. Let's move back to who your professionals are. You have an accountant who may do one or several functions for you. Certainly the most common, of course, is preparing income tax returns. You may use them for some of your business relationships. And there's also, in many cases, a good choice for somebody who is going to be able to give you advice on your estate planning. And then attorneys, obviously, this also applies to accountants. It's important to select people who can do what you need to have done. If you have a piece of litigation, you're involved in a car accident or somebody is suing you, it's important to have somebody who has experience as a litigator in that particular area of controversy. That's not the same person necessarily, however, who's going to be giving you estate planning advice. And that's the same with an accountant who may do auditing for your company, may not have considerable experience in estate planning. So I think it's important for you to select an attorney and an accountant, not who can do everything, but when you have this particular project going on, use your advisors who have some specialty in this particular area. And so one of the documents you'll see that I also am going to be attaching is a series of questions that you can ask an attorney who you are interviewing to see if this person is the right person for you to do your particular estate planning. How do you get those? How do you find those names? Ask your accountant. Ask friends who have recently gone through estate planning. Ask a friend who has similar financial circumstances that you're in as well.
Okay, Robert, we've got a couple questions here, and I will just say that I can attest to the value of having multiple people involved in this rather than the one person does everything, because they provide a nice check and balance to each other. We've had attorneys set something up that the financial planner said, no, that's not the way to do it. We've had financial planners wanting to do something that the attorney says, no, that's not the way to do it. So it's a good team to put together. So Jen, and this may actually feed into why it's good to have people with this expertise, Jen has a question that says, what claims can a nursing home make against your trust after your death?
Well, I'm assuming the claims of the nursing home you're talking about are financial claims for unpaid bills. So the nursing home would be a creditor just as any other creditor. So creditors have a right to be paid before beneficiaries have a right to be paid. Your trust does not insulate. If the assets from your trust were your assets, they don't insulate you against your creditors. If the trust was created by your parents and the assets in that trust are inherited assets, yes, they're protected. So nursing home claims, yes, can be made against wherever your assets are held after death, including, believe it or not, those transfer on death accounts as well.
And then a question about executors. Should they be local and reside near the author of the will? Is that something that makes sense to you, or is it okay for them to be away from the area? And then the question along with that is, should you have multiple people as executors of the will? Is that something that is common, and does it make sense?
Yeah, I'd say it depends on what your assets are. It's very common to have, to name an executor who does not happen to live nearby where you are. As a matter of convenience, understand the fact, if the assets are, if you rent an apartment and your assets are at Wells Fargo and other large companies, asset management or bank account companies, and you're dealing with IRAs that are with Fidelity and other places like that, you can do that from any place. Cleaning out the apartment is a problem and requires somebody to be on the job at the time, especially immediately after death. You want to be able to have somebody who can immediately get in, change the locks on the door, make sure that you know, pipes don't freeze if you happen to be up here, those kinds of things. So it's helpful to have a local person for immediate needs. However, it essentially does not have to be. You can have more than one executor. You can have multiple people. An executor can hire somebody locally to oversee and to get in there to do what needs to be done. But think of it as any other sort of quasi-business transaction, that if there is a need to be physically in a location, yeah, it's nice to have somebody who is local but not essential. I'd say get the best person for the job who is responsible and intelligent and can make good decisions, and let them decide whether they want to hire someone locally to take care of it.
And we have one follow-up question. I'm going to interject here just to keep us moving along. And it goes back to the claims from nursing homes against your trust. That there's questions about whether the state can come pursue your assets to repay Medicare bills. I'm going to suggest that maybe when you get the link.
Yeah, I'll answer.
Oh, you can answer that?
Yeah,
okay.
Let me just say, first of all, Medicare is a federal plan, so no state, that's federal, so no state's going to be going after you. I think you're thinking Medicaid, which is a medical plan for indigents. And a lot of people will do Medicaid planning. There is a group of estate planners who call themselves elder law attorneys. These are people who focus, in many cases, on Medicaid planning, setting up special kinds of trusts that allow you to transfer your assets in such a way that technically impoverish you and make you eligible for these Medicaid programs. And so rather than answer that question directly, I would suggest that in your planning you look to somebody who is an elder law specialist, but also recognize that their focus is once again on Medicaid, and they may not be quite as broad in their planning experiences, especially when you want to include charitable organizations in your estate planning.
She says, better call Saul.
Right.
So, and I'll also encourage you, at the end of this, we're going to tell you that Robert's email is available, and if you have some specific questions to the extent that he's able to answer or direct you to somebody who can give you information that may help you as well.
Okay, and then as I said, there are interview questions that you'll see in the attachment. The third attachment is just my attempt to define some of these will, trust, and other things that we talked about today. So in a week or so when all these are available, hopefully you'll be able to download this and be able to move forward with your estate planning. Involving family, do you involve them or not? I happen to believe you do involve them, but understand you are the one in control, but also recognize that they're the ones that are going to be impacted by your decisions. There are certain times when I think it's important, especially the people who you are naming to take over for you if you become disabled or on your death. These people have to have information. You just have to figure out in your own mind when you're most comfortable doing it, but that's really about all I can say at it. You'll find that different stages in their life they're able to absorb and take more information. So in closing, you're the one who are in control. Your planning should reflect your values. So you can use trusts to protect young or inexperienced heirs, allow use of their assets in what you believe is important. For example, you can set up a trust while a child or somebody is under, say, the age of 30, and you allow invasions of principal to be made for education purposes. This is a reflection of your values. You've decided that education is so important that you're actually going to allow assets from the trust beyond just the income to be used to educate. And you might extend the term of the trust until that person has developed some experience and maturity with respect to investments. Charities that you currently give to, charities that are important in your life that you volunteer from, places like RIT, if they're impactful during your lifetime, they should be part of your estate plan as well. And I'm going to be doing another webinar in a couple of months, and this is one of the areas that I'm going to be talking about as well, on how to include beneficiaries of all stripes. So with that, I think we go.
We've got a couple. Yep, we've got a couple more questions up here. One question is, what are things to consider if a parent wants to sell a piece of property and distribute the funds to their children prior to the parent's death?
Excuse me. Well, several things. If it's their primary residence, and it's be aware that an individual can recognize up to I think it's $250,000 of capital gains on a piece of real property. So a husband and wife, I believe, can sell their primary residence and have $500,000 of capital gains forgiven. So number one is that if they're selling it during their lifetime, be aware that there is some potential capital gain. That capital gain, by the way, disappears if it's held until death. The second thing to consider is if we're talking distributing the funds to children, they may be running up against the gift tax. So estate taxes and gift taxes are basically the same taxes. They are taxes on the privilege of transferring assets. If you transfer assets as a result of death, they may be subject to estate tax. If the transfer is made during lifetime, they may be subject to gift tax. The federal estate tax doesn't kick in until your assets are in excess of, I think it's $5.25 million this year. Various states have their own estate tax scheme. New York is about, I think it's 3.3 this year, and on its way up to 5.3, will be up to the federal in about 2 years. So estate tax may be an issue. Gift tax, for federal level, the gift tax doesn't really come into play until you exceed $5.3 million. So that $5.3 million can be used to transfer assets at death or during life or by some combination of the two. And the only issue there is you have to notify the IRS that you've made a gift transfer if you give more than $14,000 to any one person during any one calendar year. So husband and wife can give $28,000, and that number, by the way, is tied to inflation, but it goes up in $1,000 increments, but I think it's at 14 this year. And so you have to file a gift tax return at the same time you file an income tax return, and all you're really doing is saying, I've made a $100,000 transfer to my child A and $100,000 to child B, and $14,000 is protected, and so I'm using up what's that, $86,000 times 2 against my $5.3 million. So all they're really doing is just saying I'm eating into that bank on my death, and if they have less than $5.3 million, no one has to worry about it, or it's combined with good planning, less than $10 million, don't worry about it.
Okay, we have a question about the professional credentialing groups, whether that is a place that you can go to get lists of attorneys and estate planners in your area, and what people's credentials are?
Yeah, attorneys normally don't get credentialing. Their credential is the JD. I would suggest you can go to the local bar association. In New York State, one of the questions you'll see, there are a lot of questions on the thing I'm handing out next week that you'll be able to access, and one of the questions you specifically ask, especially for those who live in New York State, is are you a member of the New York State Bar Association? An attorney in New York does not have to be a member of the New York State Bar Association. That's a voluntary association. Maybe 35% of the attorneys in New York actually belong to it. And there are about 7, 8, 9, 10 divisions in that association, one of which is the Estate and Trusts Group. So, and that's a question to ask. Are you a member of the New York State Bar Association? If so, what committees or sections are you a member of? And you find out if they're a member of the medical malpractice and the litigation and the criminal defense litigation, well, chances are fairly good they're not spending a lot of time doing estate planning, and you might want to move to somebody else. You can also, I think most of the internet sites will do this, the American Council of Trust and Estate Council, which I happen to be a member of, that's actec.org. You can access there, and you'll see a list of the 3,000 members of the United States and abroad that are members there. That's a pretty good place to start, too.
Okay. And I think you opened this by saying estate planning is for planning in case of unplanned life experiences. So the question is, what happens if your parents pass away and do not have the legal documents that you discussed?
Then they have died what is called intestate, without a testamentary document. And the laws of the state in which they reside will control how the assets pass. And generally, I can tell you New York, basically if a person dies with a spouse, the spouse gets the first $50,000, and then depending on the number of children, gets either 1/3 or 1/2 of the remaining. If they both died and there are just children, then all the children inherit equally. If one of those children has died leaving grandchildren, then the grandchildren will take the deceased child's share. So they get passed how you would probably expect they would get passed if there are close relatives. The problem is, what happens if there's an estrangement with one of the children or more of the children, or the nearest relative is a second cousin? in any event, there's not a provision for dealing with those circumstances. The estranged child is going to inherit just like everybody else would. And my theory is, just like anything else, I would rather control where my stuff goes than have New York or any other state where I might happen to reside make those decisions for me. And also, there is a group of people who will be named as the administrator to administer the estate. Somebody still has to be appointed to operate, to close out the bank accounts, to pay the debts, to pay the funeral expenses. So you're still going to be dealing with the probate court, only you're dealing with the probate court in a way in which there's no will, and so the laws of intestate succession take place. So
thank you.
Avoid it if you can.
Okay, that is actually at the end of our time here for Q&A, and you can email additional questions to ritalum@rit.edu or tweet them to @RIT_alumni with the hashtag #MeRITWebinars, and we will direct your questions to Robert. You will also receive, all participants will receive an email from us in the next few days that will have a link to today's webinar recording. And remember, when you receive that email, that they will also have the documents that Robert has referenced for you to prepare your own estate planning. They will be available in a link in that email. We are not spamming you. We are sending you the links to the documents. We can't actually attach them, but there will be a link that will take you to the documents. Thank you very much. Robert, can you click me down one more there? Thank you. Many thanks for speaking with us today, Robert. I think people really enjoyed it and got enough information that they're now all worried about how they do their estate planning. So we'll have another webinar coming up shortly. Keep an eye out for the email about the next webinar. We invite you to listen to our nationally renowned trust expert. That's not trust as in financial, it's trust as in emotional. Bob Whipple. He is joining us for the second time on September 17th with a new webinar called Planting the Seeds of Trust in the First 10 Seconds. Thank you all again for joining us. Please, oh, I'm sorry, Robert, did you have one more thing?
Bill, you have one question. I'll just say the answer to that is true.
Okay. And please feel free to email Robert as well. He's very helpful and very willing to, as I said, either answer your questions or direct you to the person who has the appropriate authority to answer those questions.